They thought he was just another Hollywood actor, until Chief Justice John Roberts tried to humiliate Keanu Reeves in front of the Supreme Court. But what Keanu revealed next left the nation stunned and turned a courtroom ambush into a historic moment no one saw coming. Why was he really there, and what was he hiding? Before we continue this incredible story, let us know where you're watching from. If you enjoy stories like this, subscribe to the channel, because tomorrow we have another inspiring story you won't want to miss. The line outside the Supreme Court had started forming before sunrise, even though most assumed today's hearing would be a procedural affair. The docket read United States v. Bellows, a case centered on the government's power to seize private property without criminal conviction, especially in underserved, predominantly minority. But one unexpected detail had turned this otherwise quiet proceeding into a national curiosity. The court had granted 10 minutes of oral argument to a man most Americans knew not from law, but from the silver screen: Keanu Reeves. Few knew that for the past 6 years, Keanu had quietly pursued a law degree at UCLA, studying late at night, between filming schedules and charity work. He hadn't mentioned it in interviews. There'd been no headlines, no cameras following him into lecture halls. To his classmates, he was the quiet older guy who asked pointed questions and kept to himself. To his professors, he was the rare student who read not just the required material, but the original drafts of legislative texts and obscure 19th century footnotes. And now, to the surprise of many in the legal world, he had offered an amicus brief in the Bellows case, so compelling that the court, despite its usual reserve, had extended him a speaking role. He was spread across the courtroom gallery as Keanu stepped through the heavy double doors. He wasn't flanked by a legal team or stylists. No entourage, just a simple, dark suit. His hair was pulled back in a quiet nod to decorum, and in his hand was a worn, soft leather briefcase, scuffed at the corners, its handle wrapped with electrical tape. He looked more like an aging public defender than a movie icon. Still, the air shifted as he entered, subtle but unmistakable, like the hush before a storm. At the bench, Chief Justice John Roberts glanced down at the schedule. His brow furrowed faintly. Reeves? He had skimmed the brief earlier in the week, mostly expecting actor-turned-activist rhetoric. The content had surprised him. The citations were deep, the constitutional argument novel, but still, Roberts had spent decades in the law. He wasn't about to be dazzled by a celebrity's amateur theory. As Keanu found his place at the podium, legal elites in the room whispered among themselves. A Harvard-trained litigator 2 rows back smirked and murmured, "This should be good." One law clerk whispered to another, "They gave him 10 minutes? Must be for the cameras." But Keanu didn't flinch. He opened his briefcase slowly and pulled out a handwritten set of notes. No laptop, no legal pads printed with firm logos. Just ink, underlinings, and paper softened by hours of use. As the court fell into silence and the justices straightened in their chairs, he took a breath. His eyes, calm and unblinking, met the bench. The clerk's voice rang out. "Mr. Reeves, you may proceed." Keanu looked up. His voice was steady, unamplified, yet it reached every corner of the chamber with a calm gravity. "Mr. Chief Justice, and may it please the court," he began. "Today's question is not only about the legal limits of civil forfeiture, but about the moral cost of removing homes, churches, and family-run stores from people who were never charged with a crime." His cadence was slow, deliberate, every word precise. "The Fifth Amendment," he continued, "requires more than a thin claim of public use. It requires fairness. It demands justification." He flipped a page. Yet in the Bellows case, the government seized an entire apartment building based on an anonymous tip and one incident involving a visitor, not the owner. That's not due process. That's displacement dressed in paperwork. From the bench, Chief Justice Roberts leaned back slightly, his fingers steepled beneath his chin. The rest of the room was unnervingly still. Keanu held up a faded photograph. "This is Margaret Bellows. She's 73. She owned that building. Lived in the top floor for 28 years. Rented the rest to veterans, working mothers, and retired teachers. She was never arrested, never even questioned. But one arrest of someone she didn't know happened on her front steps. And the government took everything." A wave of discomfort moved through the gallery. Even seasoned legal observers began sitting up straighter. From behind the bench, Roberts cleared his throat. "Mr. Reeves, you mentioned fairness, but this court has long held that civil forfeiture is a necessary tool in combating organized crime and drug trafficking. Are you suggesting we remove it altogether?" Keanu paused only for a beat. "No, Your Honor. I'm suggesting we restore it to its constitutional roots. Forfeiture is appropriate where owners are complicit. But when no charge is filed, when no trial is held, when the property is taken and sold without a shred of due process, we've crossed a line." A quiet murmur rose from the back of the room. Keanu continued, now referencing 19th century rulings, even citing Madison's original draft of the Bill of Rights. "Our founders believed the government's power to seize property must be constrained by rigorous protections," he said. "Otherwise, power becomes predation." Justice Sonia Sotomayor glanced at her colleague Justice Kagan, eyebrows slightly raised. And Keanu, still calm, turned to his final page of notes. "In Bellows, the seizure wasn't justice. It was convenience. And that's not what our Constitution was written to protect." Chief Justice Roberts leaned forward again, this time with a sharpened tone. "Mr. Reeves, while I appreciate the passion behind your argument, it is difficult to imagine that someone from your background, however sincere, fully grasps the constitutional intricacies at play here. You are not a scholar of the law. You are, well, an actor." The jab hung in the air, heavy and cutting. A few gasps rose from the back rows. One reporter's pen froze mid-sentence. Keanu didn't blink. He met Robert's gaze. His voice didn't waver. "Respectfully, Your Honor," he replied. "I earned my JD from UCLA Law, graduating with honors. I completed my coursework in the hours between filming and visiting wounded veterans, and I wrote every word of the brief myself." Justice Clarence Thomas glanced toward Keanu, expression unreadable. Justice Kagan sat forward slightly in her chair. Keanu opened his battered briefcase, pulled out a leather-bound volume, Federalist Papers, and placed it beside his notes. "I understand that I don't fit the profile expected at this podium, but I come bearing more than credentials. I come bearing the lived consequences of what happens when power forgets humanity." He paused. "I've stood outside shelters seized in silence. I've watched seniors with nothing left but memories. I've held the eviction notices signed by the same hands that never filed charges." The courtroom was utterly silent. Keanu turned to Justice Roberts. "And as for understanding constitutional intricacies, I invite this court to examine not just the doctrine, but the damage. Bellows is not an isolated case. It's a symptom. A system used not for justice, but for revenue." Justice Sotomayor leaned in. "Mr. Reeves," she asked softly, "are you suggesting this court reconsider Bennis v. Michigan?" Keanu nodded. "Yes, Your Honor. I believe Bennis was decided in error. The precedent it set opened the door to what we see now: civil forfeiture without real cause, without fairness, and without due process. It's time we close that door." Roberts sat back, arms crossed, but now silent. Keanu looked down at the last page of his notes. His voice lowered. "This isn't about me. This is about Margaret Bellows, about every citizen whose life was reduced to a number in a ledger. The Constitution is not a suggestion, it's a promise. And today, I ask this court to keep it." As he stepped back from the lectern, The silence in the chamber was no longer doubtful. It was respect. Before Keanu Reeves even stepped into the Supreme Court, his amicus brief had already become a punchline in legal circles. "Neo goes constitutional," one blog mocked. A late-night host joked that Reeves probably thought amicus was a Matrix character. The media ran with it, some out of skepticism, others out of subtle disdain. After all, what did an actor know about the Fifth Amendment? What they didn't know was that the man they were ridiculing had spent the last 4 years in silent, persistent study. Between filming schedules and charity appearances, Keanu had been poring over foundational texts, auditing night classes at UCLA, and working privately with 2 constitutional law professors who admired his humility and hunger to learn. He didn't want recognition. He wanted understanding. And when he wrote that 36-page brief, it wasn't a publicity stunt. It was the product of over 1,200 hours of solitary research. The case at the center of it all, United States versus Bellows, wasn't glamorous. It involved a cluster of homes on the south side of Phoenix that had been seized after a single incident near a community-run health clinic. The federal government claimed the clinic had become a hub for illicit prescriptions, though no criminal charges were filed. The owners of the surrounding homes, mostly Black and Latino families, had lived there for generations. Suddenly, without warning, their properties were frozen, their titles revoked, and their lives thrown into chaos. The clinic had been started by a retired nurse named Lucinda Bellows, who had used her pension and a crowdfunding campaign to build something that mattered. She offered free blood pressure screenings, diabetes education, and warm meals twice a week. Her only crime was proximity. The DEA had cited the clinic's location as justification for a civil forfeiture action. No one had been convicted. No one had even been questioned, yet 22 families were being pushed out of their homes under the premise of public interest. Keanu had found the story through a quiet justice reform nonprofit he'd been funding for years. Something about it broke his heart and infuriated him. It wasn't just the injustice, it was the pattern. And when he began researching, he found similar cases stretching back decades. What began as a Hollywood star's curiosity turned into a legal obsession. He didn't just want to speak. He wanted to redefine how the Fifth and 14th Amendments should be understood in cases of property seizure, and no one, not even the Chief Justice, was ready for that. Keanu's brief didn't read like the work of an amateur. It was methodical, referencing original texts, footnoting early American case law, and drawing upon obscure property doctrines that even seasoned attorneys often bypassed. The heart of the argument was revolutionary in its simplicity, that property rights, especially in underserved communities, had never been granted equal constitutional protection, not in practice, and certainly not in enforcement. He cited James Madison's correspondence with Jefferson, underscoring that the Takings Clause was never meant to apply solely to just compensation, but to ensure public purpose and procedural fairness. Then he tied it to modern examples of civil forfeiture, where public purpose was stretched so thin it could barely be seen. But the brilliance was in the bridge he built between the Fifth and the 14th Amendments. His brief argued that seizing homes from innocent families without due process wasn't just a takings violation, it was an equal protection failure. When predominantly white, affluent neighborhoods were shielded from similar actions under the guise of community partnerships, while Black and Latino families were displaced based on speculation, the Constitution was not just stretched, it was broken. The legal elite rolled their eyes. One columnist at a major legal review dismissed the brief as a spirited but naive attempt by a well-meaning outsider. A podcast host laughed, calling it a mix of courtroom drama and freshman poli-sci. But behind closed doors, something else was happening. A handful of professors and former clerks began quietly forwarding the brief to colleagues. One veteran appellate judge reportedly told a law clerk, "It's unorthodox, but there's something in this that feels dangerously correct." Another scholar commented, It's the kind of argument the courts should have been hearing 20 years ago. What shocked even the skeptics was the list of signatories who joined the amicus. Among them, a former Solicitor General, 2 retired federal judges, and the National Coalition of Urban Housing Advocates. They weren't endorsing a movie star. They were endorsing an idea whose time had come. Still, the courtroom remained hostile. When word spread that Reeves had been granted 10 minutes for oral argument, the press painted it as tokenism. Let the actor speak his piece. One op-ed quipped, "It'll be good optics and harmless in the end." But Keanu didn't care about optics. While others whispered about reputation, he was thinking about Lucinda Bellows and the families still living in limbo. He wasn't stepping up to prove something about himself. He was stepping up because no one else had. And whether they laughed or not, he knew the truth had to be said. Clearly, plainly, and on the record. The Bellows case had started quietly enough. Just another property forfeiture bundled under a federal urban renewal initiative. But what no one expected was the human toll it would reveal. A dozen homes near a struggling community clinic in South Los Angeles had been flagged for seizure, not because of illegal activity on the properties themselves, but because of a single drug arrest that occurred in an adjacent alleyway. No charges were filed against any of the homeowners. No one was accused of wrongdoing. Yet the government's claim was that the entire block had become incidentally compromised and therefore subject to emergency condemnation. Keanu had visited that block more than once. He didn't come with a camera crew or a press agent. He came because of a woman named Lucinda Bellows, who'd written a handwritten letter to his nonprofit about her house being taken. A retired nurse, Lucinda had lived in her modest blue bungalow for 43 years. She helped deliver hundreds of babies at the very clinic the government now deemed a security risk. When Keanu met her, she was sorting through a box of her late husband's war medals, trying to decide which ones to keep before eviction. That meeting stuck with him. Her voice, her resilience, the way she never once asked for charity, only fairness. It reminded him of his mother, of the neighborhoods he grew up around, of what it meant to lose something you built your whole life around and be told it no longer mattered. That's what drove him. Not headlines, not appearances, but the look in Lucinda's eyes when she asked, "Can the law still hear someone like me?" He had spent 4 years studying law in secret, reading cases at night after film shoots, cross-refurbishing precedent in trailers between takes, spending weekends with professors who thought they were mentoring an eccentric philanthropist, but soon realized they were working with a genuine mind. One professor at UCLA described Keanu's approach as relentless humility. He never pretended to know, but he never stopped until he did. In his brief, Keanu wrote, "The Constitution does not bend around convenience. It cannot be a tool of silence when its soul was born to speak for the defenseless." By the time the brief reached the court, Lucinda's house had already been bulldozed. But her story lived in every footnote, every citation, every carefully constructed paragraph. And now he was walking into the Supreme Court, not for her alone, but for every family like hers, in every city that had been told they didn't matter. Outside, cameras snapped as he climbed the steps. Inside, no one could yet see what was coming. The courtroom was packed, though silent enough to hear the faint shuffling of papers and the occasional soft cough echoing off marble. Supreme Court watchers, law students, and reporters filled every available seat. Their curiosity piqued not just by the high-profile nature of the Bellows case, but by the presence of an unexpected voice. Keanu Reeves stood at the lectern, posture relaxed but purposeful. The moment had arrived. He opened the small, weathered leather briefcase he had brought, an object that seemed almost symbolic in contrast to the sleek binders and polished tech used by seasoned litigators. From it, he pulled a few handwritten notes and a pocket constitution with corners worn from use. "Mr. Chief Justice," he began, "and may it please the court." But he didn't get past the second sentence. "Mr. Reeves," Chief Justice John Roberts interrupted, his voice clipped and unmistakably pointed. "With all due respect, the Constitution is not a screenplay. We are not here to audition new interpretations." There was a collective intake of breath. A law clerk paused, pen frozen mid-scribble. A professor in the gallery straightened in her seat. Several journalists looked up at once. Keanu didn't flinch. He met the Chief Justice's eyes, his voice steady and low. "Your Honor, I fully agree, which is why my argument comes not from fiction, but from the founders themselves. In 1795, this court in Calder v. Bull held that laws violating fundamental justice were void, even before the 14th Amendment was ratified." The Chief Justice blinked, caught off guard by the direct historical citation. Keanu turned a page in his notes. Justice Chase wrote then that there are principles of natural justice that no legislature can ignore. I believe what's happening in Bellows falls within that category. Whispers passed like wind across the gallery. The temperature in the courtroom had shifted. Justice Kagan leaned forward slightly. Roberts narrowed his eyes, but he didn't interrupt again right away. Keanu used the opening. "Your Honors," he continued, "the Fifth Amendment protects not only against physical seizure, but against erosion of property rights without fair cause. The homes seized in Bellows were never linked to any crime, no owner charged, no hearing granted. And yet, under civil forfeiture laws, the government simply took them." Justice Alito tapped a finger on his armrest. The argument was beginning to sound familiar, but different, structured, grounded, original. Justice Sotomayor exchanged a look with Kagan, equal parts intrigue and surprise. Keanu Reeves wasn't performing. He was prosecuting truth. Chief Justice Roberts, perhaps unwilling to concede ground so easily, cleared his throat and leaned forward. "Mr. Reeves, your brief argues that the concept of public use in the Takings Clause was originally intended to involve not just use by the public, but actual, tangible benefit. But the court has recognized economic development as sufficient public use since Kelo v. City of New London. Are you suggesting we disregard that precedent?" Keanu didn't shift under the pressure. "No, Your Honor. I'm suggesting we realign our interpretation with what the founders intended and what the court itself has since acknowledged were the limits of Kelo." He flipped to a marked page in his worn Constitution. As Justice O'Connor warned in her dissent, Kelo opened the door to abuses, particularly in vulnerable communities. And that's exactly what happened in Bellows. Homes were taken not for public roads, not for schools, but under a promise of redevelopment that remains vague and unsubstantiated. Meanwhile, the clinic at the center of the neighborhood, which treated unassured families, was shuttered, its patients scattered. Justice Jackson tilted her head slightly, eyes narrowing with renewed interest. Keanu continued, "This case isn't just about real estate. It's about the slow erosion of dignity, of home, of belonging. The government took these properties under the pretense of public good, but offered no hearings, no proof, and no protections. That violates not just modern standards, it violates the Fifth and 14th Amendments." There was a pause in the courtroom. Roberts leaned back, fingers steepled beneath his chin. "Do you contend that the procedural safeguards in current forfeiture statutes are insufficient?" "Yes," Keanu replied. "Grossly." He reached for his notes again. "According to the Institute for Justice, over 80% of civil forfeitures happen without the property owner being charged with a crime. In Bellows, the homeowners received letters, no court date, no opportunity to contest. Some never even opened them. English common law, which this court has cited many times as foundational, required that takings be tied to wrongdoing and subject to judicial review. That's not happening here." Justice Gorsuch tapped his pen against his binder and looked toward Roberts. The silence that followed wasn't one of awkwardness, but of consideration. Keanu looked briefly down at his briefcase, then up again. "I didn't come here today because of a camera or a cause. I came because the people in Bellows had no voice. And when the law becomes something only the powerful understand, the Constitution becomes a closed door." More than one spectator had stopped taking notes. They were listening now, not to an actor, but to an advocate who had done his homework. The lights of the chamber didn't feel quite so cold anymore. Justice Sotomayor leaned forward next. "Mr. Reeves, let's explore due process further. You referenced a 1795 precedent in your opening. Which case specifically supports your claim that notice and hearing must precede property seizure in all but emergency circumstances?" Keanu didn't hesitate. "Justice Sotomayor, the case is Van Horn's Lessee v. Dorrance, decided in 1795 by the Pennsylvania Circuit Court." Justice Patterson, who would later join this court, wrote, "The right to acquire and possess property is a fundamental principle, and the legislature has no authority to transfer it arbitrarily from one person to another." He paused just long enough to let it settle. The founders didn't see due process as a formality. They saw it as a boundary between liberty and tyranny. Justice Kagan nodded faintly, then scribbled something in her notes. Roberts, however, pressed again. "And what, Mr. Reeves, would you say to the argument that these takings were part of a broader revitalization plan, intended, in fact, to benefit the same community now objecting?" Keanu met his eyes. "I would say that when the government promises revitalization and delivers vacancy and decay, that's not redevelopment. That's abandonment dressed in rhetoric." A low murmur passed through the audience. No one interrupted him. Keanu shifted slightly, placing both hands on the lectern now. His voice softened. "I walked those streets in Bellows. I visited the clinic 2 years ago before they shut it down. There was a woman named Ruby, the nurse who ran the place. She stayed open late 3 nights a week to serve single moms and elderly patients. She's now working nights at a fast food counter. Her home was taken too." He inhaled slowly, steadying himself. "Due process isn't a technicality, it's a lifeline, and the takings clause wasn't meant to serve developers or political agendas. It was meant to protect the powerless. If we let it bend every time it's inconvenient, we aren't preserving liberty, we're auctioning it off." Justice Barrett sat back quietly, arms crossed, watching him intently. Keanu's final words in his allotted time came without drama, but with gravity. The Bellows families didn't ask for special treatment. They asked for the Constitution to mean something when they needed it most. A beat of silence. Then Roberts, clearly recalibrating, finally said, "Thank you, Mr. Reeves." Keanu gave a slight nod, gathered his papers with care, and returned to his seat. But the energy in the room had changed. Skepticism had faded. What remained was something far more rare in that chamber, and no one was calling it just a performance anymore. The courtroom held its breath as Chief Justice Roberts leaned forward, voice sharp. "Mr. Reeves, surely you've considered United States versus Palmyra 1827. The court upheld forfeiture without a criminal conviction. The trap had been set." Legal scholars watching from the gallery nodded knowingly. It was a case often used to silence novice advocates, especially those with unconventional credentials. But Keanu didn't flinch. He turned a single page in his worn leather brief and calmly replied, "Yes, Your Honor. Page 31 of my brief addresses the Palmyra in detail. But I'd respectfully note that case pertained strictly to maritime law. The vessel itself was considered the offender. Justice Story wrote that such forfeitures were exceptions tied to piracy and customs enforcement, where jurisdiction over people was unavailable." Justice Kagan's pen paused mid-note. Justice Sotomayor sat forward, suddenly alert. Roberts blinked. Keanu continued, "There is no such limitation here. We are not at sea. We are talking about homes seized from landowners with no charges filed, no jurisdictional gap, no piracy loophole. The use of Palmyra as a sweeping justification for modern property forfeiture is not only ahistorical, it's dangerous." He paused. The silence was complete. Even the gallery stilled. Then Keanu reached for a slim folder. From it, he withdrew a photocopy of a handwritten 1791 letter between James Madison and Thomas Jefferson. "I brought something," he said softly. A letter from Madison, who drafted both the due process and takings clauses. He wrote, quote, "No seizure of a citizen's estate, absent a clear public wrong and judicial test, can be called just." Justice Barrett lowered her glasses to look closer. Justice Thomas looked toward Roberts. Then came the moment that changed everything. Keanu raised 3 fingers and said, "Based on the constitutional text, original commentary, and early case law, I propose a 3-part test. First, a substantial connection between the property and a proven crime, not speculation. Second, clear and convincing evidence that the owner had actual knowledge or participation. Third, proof that the forfeiture serves a legitimate public use, not mere revenue generation." Justice Gorsuch glanced at his clerk, who was now frantically typing. Keanu added, "This test would align modern law with the founders' intentions. It protects against abuse without dismantling necessary enforcement tools." He closed the folder. The Constitution isn't a screen to be projected. It's a foundation to be read. And for the first time that morning, even the skeptical justices looked genuinely curious. Justice Kagan broke the silence first. "Mr. Reeves, you mentioned Madison's commentary, but what about early state court rulings? Any consensus there?" Keanu didn't miss a beat. He opened another tabbed binder from his case file and turned to a hand-labeled section titled Early Republic Jurisprudence. His voice was calm, measured. In Commonwealth v. Parker, Pennsylvania, 1805, the court invalidated a property seizure absent direct involvement by the owner. And in Georgia's Ex parte Whitmore, 1812, the court ruled that forfeiture without indictment was, and I quote, "a dangerous tool, fit only for monarchies." I've included 6 such rulings in the appendix, all showing that land-based seizures without criminal charges were viewed skeptically, even in the first decades of our republic. Justice Kagan nodded slowly, visibly impressed. Justice Alito interjected next. "And yet, Mr. Reeves, as you know, Bellows v. Michigan upheld seizure even from innocent owners. How do you square your proposal with that precedent?" Keanu's eyes didn't waver. "With respect, Justice Alito, I believe Bellows was wrongly decided. Justice Thomas said as much in his dissent, joined surprisingly by Justice Ginsburg. It left open dangerous room for abuse, especially in vulnerable communities." He tapped the microphone. "But even if Bellows is not overturned, this court can narrow its application. Bellows involved a vehicle used directly in a criminal act. Bellows involves homes, families, a community clinic, all seized without charges. That difference matters." Justice Thomas, silent up to this point, turned his chair toward Keanu. "Mr. Reeves, what would you say is the clearest historical basis for limiting these powers?" Keanu looked directly at him. "The Northwest Ordinance of 1787, adopted by Congress before the Constitution. It required that property not be taken, but through lawful judgment and due process. That principle, grounded in both state and federal tradition, shaped the 5th and later the 14th Amendments. In short, our founders feared the unchecked seizure of land because they saw it used as tyranny." A murmur rippled through the gallery. Reporters began scribbling again. At the back of the room, a senior editor from The Atlantic whispered to his colleague, "He didn't just read the cases, he lived them." Chief Justice Roberts stared down at his notes, now visibly reconsidering the man he had dismissed minutes earlier. And Keanu, standing alone at the lectern with nothing but battered pages and handwritten notes, looked completely unshaken. Keanu drew in a quiet breath and stepped forward with calm resolve. "If I may, I'd like to present a simple framework, rooted in history, consistent with precedent, and fair to both property owners and the government." He raised 3 fingers. First, the government must demonstrate a direct and substantial connection between the property and an alleged criminal act, not just geographic proximity or suspicion. Second, when the owner is known and reachable, due process demands either a criminal conviction or clear and convincing evidence that the owner consented to or knowingly allowed the illegal activity. Third, the use of the seized property must serve a genuine public purpose, defined not by vague claims of law enforcement efficiency, but by actual remedial function, like restitution or public use, not revenue generation. He let the words hang in the air. Justice Barrett leaned forward slightly, visibly intrigued. "Mr. Reeves, I don't recall seeing that test proposed in any prior scholarship. Did you develop this independently?" Keanu nodded. "In collaboration with legal mentors at UCLA. But the language and spirit are drawn from the founders themselves. Madison, in his 1789 address to the House, warned that government power must never be allowed to trespass casually on private ownership, lest liberty itself erode." A brief silence followed. Then Chief Justice Roberts spoke again, but this time with a noticeably different tone. "Mr. Reeves, these are ambitious claims, but do you believe this court should discard decades of doctrine on the strength of your historical interpretation?" Keanu didn't flinch. "Not discard, clarify. Our jurisprudence has drifted, not deliberately, but gradually, away from its roots. This case is a chance to reconnect with the core idea that property rights are not luxuries for the privileged, but shields for the vulnerable." He paused, then added, "I've walked through neighborhoods where the Bellows doctrine has left families homeless without a hearing. I've listened to children wonder why their backyard is now a government lot. That's not constitutional order, that's quiet chaos." Justice Sotomayor looked down at her notes, then up at Keanu, eyes softer now. "Thank you, Mr. Reeves." As Keanu closed his binder, the courtroom wasn't just silent, it was transfixed. What began as an anticipated embarrassment for a Hollywood figure was rapidly becoming something more, something historic. Outside the chamber, a reporter for NPR whispered into her recorder, "He didn't come to perform, he came to teach." And inside, the man in the simple dark suit with the battered briefcase waited calmly, his time still ticking, but his presence already undeniable. The courtroom had gone quiet, not with disinterest, but with something far heavier: attention. Genuine, taut, collective attention. Keanu Reeves stood at the lectern, his voice steady but low, as he responded not to a question, but to a silence that demanded proof. "I'd like to walk the court through precedent, not summaries, the actual holdings." Justice Barrett raised an eyebrow. Justice Kagan leaned forward. Keanu didn't glance at notes. Instead, his hands rested lightly on the sides of the worn lectern as if it were a piano, and the room waited for the first key. "In 1795, he began, the case of Harmony v. United States, the court ruled that goods seized without warrant, even under suspicion, required judicial confirmation and clear evidence of criminal intent. No forfeiture was allowed where the owner was unaware of the crime." He paused for a breath. "In the Sarah, 1805, Justice Marshall warned against forfeiture extending beyond the bounds of proportional justice, arguing that civil seizure must never displace the presumption of innocence." A reporter in the gallery whispered, "Is he reciting these?" 1812, United States v. the Little Charles, again a maritime case, Piracy, property condemned because no party could claim it under oath. Not once was domestic land property involved. His voice, quiet but controlled, continued. 1827, the Palmyra. Often cited, Justice Story upheld forfeiture for piracy because the ship itself was legally considered the aggressor. A fiction, he called it, justified only by lack of jurisdiction over its crew. Chief Justice Roberts stiffened slightly. That was the very case he had tried to use against Reeves in Section 4. The weight of context was bearing down. 1833, United States versus Good Ship Mary, seizure denied. The owner proved they had no knowledge of the smuggling cargo. The court held that innocence must not be a casualty of enforcement. Justice Sotomayor uncrossed her arms, scribbling rapidly. Keanu's cadence never wavered. 1840, Loomis v. United States. The court declined forfeiture of a property used once by a criminal guest, ruling that fleeting contact didn't imply complicity. 1847, People v. Farmer out of New York, State Court. A shed was used without the owner's consent. The judge called it an overreach, both moral and legal, to transfer ownership under such flimsy connection. 20 minutes had passed, and he was only halfway through the list. There was no performance here, no embellishment, just law, lived and breathed into memory. And the room, filled with the nation's sharpest legal minds, was no longer dismissing him. He was teaching them. Justice Thomas hadn't spoken yet, but his eyes tracked every word. Keanu continued, his voice unwavering as he transitioned to the next era. 1851. United States v. 50, boxes of tea. The court reaffirmed the need for proximate cause in forfeiture cases, stating that mere suspicion of mislabeling without proof of willful deception was insufficient. He paused for breath, scanning the room, not for effect, but to be sure his argument was being followed. 1857, Rogers v. the Collector. Forfeiture denied due to lack of due process. The opinion specifically warned that civil seizures without judicial hearing risk turning government into a predator of its own people. That language, by the way, was cited in 2 law review articles in the 1980s and ignored since. The clerks' pens had slowed. They were now watching with the same rapt attention as the justices. 1864, Harper v. United States. A property used for counterfeit operations but owned by a man who had leased it to a tenant with no knowledge of the crime. The court ruled in his favor. That's nearly 70 years of precedent before Bennis versus Michigan changed course. Justice Kagan finally interjected, her tone measured but curious. Mr. Reeves, you've traced quite a lineage of cases. Did you rely on any academic researchers to compile this? Keanu shook his head, respectfully. No, Your Honor. I retrieved the original decisions from archives at the Library of Congress and UCLA Law Library. Most hadn't been cited in recent scholarship. I felt it necessary to revisit the record firsthand. We too often quote the commentary, not the text. It was then that Justice Clarence Thomas finally broke his silence. You read them yourself? He asked. His voice was steady but unmistakably surprised. Keanu's eyes met his with quiet gravity. Yes, sir. I believed I owed the court the real record, not just footnotes pulled from treatises. It seemed wrong to rely on second-hand interpretations for something this important. Even Justice Alito, often skeptical of broad reinterpretations, seemed taken aback, not by arrogance, but by the humility of Keanu's answer. In the gallery, a Harvard law professor leaned over to a colleague and whispered, "This man has read deeper than half the constitutional scholars I know." And still, Keanu wasn't done. 1873, in Re Pennington, a case where family farmland was seized because a fugitive camped there for a week. The court ruled that the land's use by a stranger did not constitute grounds for taking. It affirmed that property rights require intent, not accidents. It wasn't just that Keanu Reeves had memorized the cases. It was that he understood them. And in this chamber of high law and higher egos, the shift had occurred. He was no longer the actor making a legal cameo. He was a peer, armed with history, humility, and something more dangerous to cynicism than confidence: truth. Justice Gorsuch, known for his sharp originalist leanings, leaned forward for the first time. "Mr. Reeves, you've presented a detailed historical lineage, but history isn't always law. What binds these rulings into something more than anecdotes?" Keanu nodded, anticipating the challenge. He turned a page in his notes, revealing a hand-drawn chart. "With the court's permission," he said, "I'd like to show a pattern across all federal forfeiture cases, from 1789 to 1900. He held up the page. Columns of cases, each marked by year, citation, type of seizure, and result. Of the 31 civil forfeiture cases during that period, Keanu explained, 28 involved maritime or customs violations. 3 involved land, but in all 3, forfeiture was denied unless the property owner had direct knowledge or intent. There's a through line, one the modern doctrine has broken." Justice Barrett looked closely at the page. "And your point is that Venice and its progeny deviated from this trajectory." Keanu's voice lowered with conviction. "Not just deviated, Your Honor. They severed it." He let the silence hang. Then, gently, he added, "The Constitution isn't a set of evolving preferences. It's a structure with pillars. One of those pillars is the right to keep what's yours, unless the state proves, not presumes, your guilt." A hush fell over the chamber. Even the reporters stopped typing. For a moment, all that could be heard was the faint hum of ventilation and the distant click of a dropped pen in the gallery. Then Justice Sotomayor broke the silence. "Mr. Reeves, these cases you cite, some haven't been referenced in a Supreme Court brief in over a century. Why dig so far back?" Keanu took a breath. "Because sometimes the answers we need aren't new. They're buried. In courtrooms like this one, in letters from Madison, in quiet rulings forgotten by time but not by truth. I didn't come to rewrite the Constitution. I came to remember it." There it was, not an actor playing brilliant, a man who had studied long after the cameras stopped rolling, a man who walked into the nation's highest court, not to make a point about himself, but to resurrect a point about justice. From the gallery, someone whispered, "I think he just changed the conversation." And across the front bench, for the first time since Keanu Reeves had begun speaking, every justice was looking at him, not through the lens of celebrity, but with respect, and something even rarer in that chamber: reconsideration. Justice Amy Coney Barrett leaned slightly forward, her eyes focused, tone measured. "Mr. Reeves, your historical grounding is well noted, but I'm curious. How do you reconcile your framework with this court's ruling in Bennis v. Michigan?" Her question landed softly but carried significant weight. Keanu didn't hesitate. "Justice Barrett, Bennis involved the forfeiture of a vehicle jointly owned by an innocent spouse. The court upheld the seizure even though the co-owner had no involvement in the crime. I respectfully submit that Bennis was wrongly decided." A quiet murmur stirred through the chamber. Keanu continued, voice calm but resonant. "It overlooked the intersection of the Fifth Amendment's Takings Clause, the 14th Amendment's Due Process Protections, and the 8th Amendment's Excessive Fines Clause. In doing so, it created a framework where innocent people could lose their property without meaningful recourse." Justice Barrett nodded slowly. "That's a bold position. Many courts have relied on Bennis for years." Keanu opened his brief again, revealing a page marked with 3 tabs. "And yet, since Bennis, this court has ruled in Austin v. United States and Timms v. Indiana that civil forfeiture must conform to proportionality principles. If we accept that forfeiture is quasi-criminal, then it cannot escape scrutiny under the excessive fines clause. He stepped aside from the lectern, picking up a slim folder he'd brought with him. With the court's permission, I'd like to reference an image. Not for emotional appeal, but as part of the legal record. Chief Justice Roberts, now notably quieter than earlier in the day, gave a small nod. Keanu held up the photograph, a modest brick house with a rusted porch swing. This home, seized by local authorities in Ohio under civil forfeiture laws, belonged to the Bellows family. No criminal charges were filed. Their only fault? A neighbor's alleged activity on the sidewalk nearby. He handed the image to the clerk to pass among the justices. The Bellows family were evicted while their youngest son was recovering from surgery. Their case forms the very foundation of the matter before this court. Justice Sotomayor adjusted her glasses as she studied the photo. Keanu's tone never wavered. This isn't an abstract debate. When government seizes property from innocent citizens without clear conviction or demonstrable intent, we aren't just discussing legal doctrine. We're addressing systemic harm that disproportionately impacts vulnerable communities. Justice Kagan leaned in. And what standard would you propose to prevent that? Keanu met her gaze evenly. A restoration of proportionality, a reaffirmation of intent, a return to what our Constitution actually demands. Justice Barrett's expression remained thoughtful, even as she pressed again. Mr. Reeves, if Bennis was wrongly decided, do you believe this court should overturn it outright? Keanu drew a breath, steady and unhurried. Justice Barrett, I believe this court has two responsible paths. One is explicit overruling. The other, and perhaps more faithful to the doctrine of judicial restraint, is distinguishing Bennis from the present case based on evolving precedent and clarified constitutional interpretation. He turned a page in his binder and held up another reference. Since Bennis, the court's reasoning has evolved. In Timms v. Indiana, this court incorporated the excessive fines clause against the states, establishing that civil forfeiture can be subject to Eighth Amendment review. The majority opinion acknowledged that excessive seizure without due process is by nature unjust. Justice Kagan nodded slightly. Keanu pressed forward. The Bellows case offers the clearest opportunity to establish a three-part standard. First, a substantial connection between the property and criminal activity must be demonstrated. Second, the government must meet a clear and convincing burden of proof that the owner had knowledge or intent. Third, the seizure must not be grossly disproportionate to the harm caused. Chief Justice Roberts, silent until now, spoke up again. But how would such a standard avoid unintended consequences? Would it not handcuff law enforcement in legitimate seizure operations? Keanu responded respectfully. With all due respect, Chief Justice, my framework doesn't weaken lawful forfeiture. It strengthens constitutional accountability. Law enforcement remains empowered to act, especially when there is clear criminal conduct. What it prevents is punishment by proximity, where innocent families become collateral damage. Justice Thomas leaned slightly forward, voice quiet but firm. Do you have evidence of disproportionate impact? Keanu didn't flinch. Yes, Justice Thomas. According to a 2022 study from the Institute for Justice, 84% of civil forfeitures under state laws occurred without any accompanying criminal charge. And of those, the majority were valued under $1,500.00, indicating that these seizures overwhelmingly affect the poor. He took another document from his folder. I've submitted a friend of the caught brief with affidavits from community members whose homes were taken due to suspected conduct by others. In none of these cases was a criminal conviction ever obtained. Barrett's voice softened. And yet, until today, you never publicly discussed your legal education or these efforts. Keanu offered a small, tired smile. Because the law is not about the spotlight. It's about who's left in the dark. Justice Sotomayor blinked slowly at that. The courtroom fell into a momentary hush, not out of skepticism, but something deeper, a recognition. Keanu gently placed a laminated photograph on the lectern, holding it steady with one hand. The image faced the justices. It showed a modest two-story home in Newark, New Jersey, its windows boarded, its lawn overgrown. In the foreground, a young girl sat on the curb, clutching a stuffed animal. Her mother stood behind her, holding a notice of seizure. No criminal charges were ever filed. This morning, this, Keanu said quietly, was the Bellows residence. Seized by the government after a distant relative, never a tenant, was arrested in a nearby alley. The child you see here, Ilana Bellows, was 9 years old. That stuffed bear was the only thing she was allowed to take. Justice Kagan leaned forward. Justice Sotomayor's brow furrowed. "This isn't theater," Keanu continued. "This is evidence, submitted alongside a sworn statement from the family. They were never given a hearing. The seizure occurred before they had a lawyer, before they were told what, if anything, they had done wrong." Justice Gorsuch folded his hands, his eyes fixed on the photo. "Was this addressed in your brief?" "Yes," Keanu replied. "Appendix C, I included 4 such cases to demonstrate systemic misuse of civil forfeiture powers, not to appeal to sympathy, but to prove a pattern of due process failure." Justice Alito, usually reserved in matters of systemic reform, raised a brow. "Why you, Mr. Reeves? Why this issue?" Keanu met his eyes with calm sincerity. "Because I've spent the last decade working with shelters, food banks, and community legal clinics, and I kept meeting people whose lives were torn apart by legal processes they never understood. I couldn't keep pretending that justice was someone else's responsibility." There was a pause. Then Keanu continued, his voice softer now. "When I studied the original intent of the Fifth Amendment, I found something striking. Our founders feared government overreach more than they feared individual wrongdoing. Madison, in 1791, called unjust takings a quiet tyranny." He looked across the bench, not with challenge, but with conviction. "And if this court allows property to be seized from the innocent without criminal proof or meaningful recourse, then that quiet tyranny grows louder. It may be legal, but it is no longer just." A deep, still silence followed. Even the reporters stopped typing. Then Justice Barrett gently nodded. "Thank you, Mr. Reeves." Keanu stepped back, not with triumph, but with the gravity of someone who had just placed a burden before the court. And now, it was theirs to carry. A quiet tension hummed through the chamber, no longer the kind that signaled doubt, but a new kind, the kind that meant something unexpected was happening. Keanu Reeves stood behind the lectern, unshaken, his voice steady, his posture humble but confident. The marble columns of the Supreme Court had seen hundreds of advocates. Few had shifted the air like this. Justice Kagan leaned forward first, pen poised over her yellow legal pad. "Mr. Reeves," she said, her voice carrying the weight of curiosity, not challenge, "your brief draws a clear link between historical intent and modern deprivation. But you also seem to suggest a broader interpretive bridge, one that connects procedural fairness to substantive outcomes. Am I hearing that right?" Keanu met her gaze, respectful but direct. "Yes, Justice Kagan. The founders didn't merely fear the taking of things. They feared the erosion of liberty through subtle forms, processes that looked neutral but function as punishment. Property seizures without notice, or with weak procedural safeguards, were exactly the kind of slow tyranny Madison wrote about. Due process, in their minds, wasn't an obstacle. It was the soul of legitimacy." A murmur passed through the rows of law clerks and court reporters. Justice Kavanaugh adjusted his glasses. I've read dozens of amicus briefs on takings and forfeiture, but I've never seen one argue that the takings clause and due process clause are so intertwined. Why didn't we see this before? Keanu didn't hesitate. Sometimes the law hides in plain sight, until someone with everything to lose and nothing left to prove brings it into the light. Silence followed. Not the kind of silence that demanded a rebuttal, the kind that followed revelation. Justice Sotomayor leaned back in her chair, arms crossed, studying him. The last 20 minutes had changed her posture, her expression, her pace of note-taking. Her skepticism had given way to attention, then admiration. Then Chief Justice Roberts, who until now had remained silent after his early interruption, cleared his throat. Mr. Reeves, earlier in your presentation, you referenced the 1795 case of Van Horn's Lessee v. Dorrance. You claim it illustrates a property rights doctrine distinct from our modern jurisprudence, yet most scholars view it as an anomaly. Why give it so much weight? Keanu opened his battered briefcase, pulled out a photocopy of the original court record, and placed it on the podium. Because the anomaly has become the rule. That case wasn't fringe. It was foundational. We just stopped listening. The chamber was listening now. The justices sat more upright now. What began as a routine appearance by a celebrity had evolved into a dialogue no one expected. Keanu Reeves, once dismissed as a Hollywood visitor in legal robes, was being treated like a peer, one whose research and reasoning now commanded the full attention of the most powerful legal minds in the country. Justice Barrett, sharp-eyed and thoughtful, tapped her pen twice before speaking. Mr. Reeves, you've drawn extensively from early American jurisprudence, but our court must consider stability, reliance, and judicial restraint. You mentioned in your brief that modern forfeiture disproportionately affects minority communities. What empirical support do you offer? Keanu nodded slightly, as if anticipating the question. Justice Barrett, I've attached 5 appendices to the brief. Appendix C cites data from the Institute for Justice showing that in over 30 states, 78% of civil forfeiture proceeds come from low-income, predominantly minority neighborhoods. In many cases, those citizens were never even charged with a crime. He paused, then added gently, the Constitution doesn't permit us to ignore systemic patterns simply because they evolve slowly. Justice Gorsuch leaned forward. So what remedy do you propose? You're not asking us to strike down forfeiture entirely? No, sir, Keanu said. Only to restore its original bounds. Maritime seizures, contraband, true criminal proximity, but not homes seized for what someone's cousin may have done on the sidewalk. That's not justice. That's erosion. Whispers passed through the gallery. Legal journalists were scribbling furiously now. One clerk was visibly shaking their head in disbelief, not at Keanu's argument, but at how it had shifted the entire tone of the bench. Then, perhaps the most surprising moment of the day came. Not from a justice, but from Roberts himself. His voice had lost the edge it carried earlier. Now it was measured. Mr. Reeves, he said carefully, in your critique of this court's past decisions, particularly your references to Bennis and Palmyra, do you mean to suggest we've lost sight of the balance between enforcement and liberty? Keanu didn't look triumphant. He didn't smile. He simply looked tired and sincere. Your Honor, I believe the court has always tried to balance those values. But in the shadow of national security and revenue enforcement, the scales have tipped too far. We're not just taking property anymore. We're taking trust from people who can't afford to lose either. The courtroom fell still again. And this time it wasn't silence of curiosity. It was silence of respect. Justice Kagan adjusted her glasses and leaned forward. Mr. Reeves, you reference a letter from James Madison to Jefferson in your supplemental notes, stating that property rights without procedural safeguards are a hollow promise. Is that where your framework begins? Yes, Justice Kagan, Keanu answered. That letter, dated May 22, 1789, outlines Madison's belief that due process was inseparable from just compensation. Madison didn't treat property rights as an isolated concept. They were woven into the very fabric of what it meant to be protected by law. Justice Sotomayor, who had been listening with her arms folded across her chest, now uncrossed them and lifted her pen. And how does your framework handle disproportionate harm? For instance, if a small home is taken over an accusation not supported by a conviction. Keanu didn't pause. Under the test I propose, Justice Sotomayor, the seizure fails on 3 fronts. First, it lacks proximate cause. Second, there's no adjudicated knowledge or intent. And third, the use of proceeds from the seizure does not serve a constitutionally valid public use. That third point, the misuse of funds, is where many modern practices collapse. There was a murmur of agreement from the back row of law clerks. Justice Kavanaugh returned to his earlier question. Mr. Reeves, you said something earlier that struck me. Sometimes the law hides in plain sight. Can you explain what you meant by that? Keanu's voice lowered slightly. I meant that sometimes, especially in a country as complex as ours, old protections are buried under layers of procedure and policy. It takes someone with nothing to gain, someone no one expects, to point to the original blueprint and say, "We've strayed too far." He let that sit for a second, then added, "I'm not here to dismantle the system. I'm here to ask if it's still serving the people it was written to protect." It was then that Roberts, who had been silent through the last round of questions, finally spoke again. This time, his tone was different, measured, maybe even a little humbled. Mr. Reeves, your presentation has been illuminating. It wasn't an admission of fault, but it was close. Justice Thomas nodded slightly. Justice Breyer glanced at his notes, then closed his folder. As Keanu closed his argument with a quiet, "Thank you, Your Honors," there was no applause. There never is in the Supreme Court. But the silence that followed said everything. Keanu Reeves hadn't just held his ground. He had redrawn it. Keanu Reeves stood at the podium, the same battered leather briefcase resting at his feet. The room, once buzzing with skepticism, now held its breath. He looked across the chamber, not at the justices, but at the faces beyond them. The clerks, the reporters, the law students in the gallery, the people who didn't hold gavels but bore the weight of decisions made in rooms like this. He inhaled quietly and spoke, voice steady but laced with quiet fire. The Constitution is not just for scholars or lawyers, it's for every family who's had their door kicked in, their life dismantled, without a day in court. No one moved. No one blinked. For the first time all morning, not a single pen scratched paper. Justice Barrett looked down. Justice Sotomayor watched him without expression. Chief Justice Roberts, who had once tried to cut him down with a quip about screenplays, now simply listened. "I didn't come here to dazzle you," Keanu continued. "I came because someone had to. Because out there, in the neighborhoods we write off as statistically irrelevant, the law has become something to fear, not trust." He opened his file and pulled out a photo. One the court had already reviewed, but now held a deeper gravity in his hands. A small 2-bedroom home in East Los Angeles. Blue trim. A chain-link fence. A boarded-up window where someone had thrown a brick after the family was forced out. So the home was seized not because its owners committed a crime, Keanu said, voice tight with restraint, but because someone made a mistake, 2 blocks away. No trial, no charges, no apology. He lowered the photo. This isn't about theory. It's not even just about the law. It's about the soul of justice. Behind him, the doors had closed, sealing out the world. But the weight of that world was still in the room. Keanu stood alone, but it was clear he carried more than just his argument. He carried names, stories, pain, Resolve. "I've read the law," he said. "I've traced it back to its roots. I know what the founders feared when they wrote these protections. It wasn't pirates or smugglers, it was power, unchecked." Roberts blinked slowly, resting his chin against one hand. "And power," Keanu said softly, "should never outrun accountability." The silence in the courtroom deepened as Keanu turned the page in his notes, though he barely glanced down. His next words came from memory, but more importantly, from conviction. "When we allow civil forfeiture to drift so far from its roots, we untether justice from the people it was meant to protect," he said. "The Fifth Amendment was never meant to be a loophole. It was a warning label." He paused, letting that land. Then he added, "Due process isn't a luxury, it's a birthright." Justice Kavanaugh shifted in his seat, tapping a pen against his fingers. He wasn't challenging, he was absorbing. Justice Kagan leaned forward, watching Keanu like she was waiting for a note in a song. Roberts, who had interrupted him only minutes into his argument at the beginning of the session, now sat with both hands folded over his notes. Keanu continued, "I didn't grow up in courtrooms. I didn't grow up understanding doctrines or precedent. But I've spent the last 5 years listening, studying, working quietly with legal scholars, constitutional historians, and most importantly, people who've been broken by systems they don't understand." His voice grew steadier with every word. "I've seen the faces of families who lost their homes without being charged with a crime. I've seen children cry while government officials padlock their front doors. And I've seen how quickly a good neighborhood becomes a ghost town when fear replaces fairness." He stepped slightly aside from the lectern. "You can cite the Palmyra case. You can reference Bennis v. Michigan. But I ask this court to remember one thing. The law, while built on precedent, is meant to serve the living." He looked to Justice Thomas. "You asked earlier whether I had truly read the Madison Papers myself. I did. Every page, every scratch of ink, because I wanted to understand not just what the law says, but what it meant to them and to us." Then to Justice Barrett, "You question how this interpretation would affect law enforcement tools, and that's fair, but we can't preserve tools at the expense of people. Our loyalty must be to the text and its spirit, not its utility." A subtle nod from her. She wasn't agreeing, not outright, but something had landed. "This case," Keanu said slowly, "may be about one house, one neighborhood, but the principles at stake, they reach into every corner of this country." He returned to the center behind the lectern. "And if we don't fix it, if we don't check this misuse of forfeiture, we risk losing not just homes, we risk losing the trust that binds law to legitimacy." Keanu let the room breathe for a moment. Then he spoke one final time, without notes, without quotes. "I didn't come here today to impress you. I didn't come here hoping for attention. I came because a family in Bellows lost everything without ever stepping into this courtroom. And if that can happen once, it can happen again. It will happen again. Unless this court decides that constitutional rights mean something before the damage is done." He paused, scanning the room not with performance, but presence. "We are told that justice is blind, but sometimes it feels like it's just looking the other way." Several clerks had stopped taking notes. They were just watching now. A few journalists had their pens frozen in the air, not wanting to miss a breath. Justice Sotomayor leaned forward, with her elbow on the bench, chin resting on her hand. Her eyes didn't move from him. Then Keanu lowered his voice. "I've played a lot of roles in my life. Action heroes, rebels, survivors. But this..." He gestured gently toward the bench, the building, the gravity of where he stood. "This isn't a role. This is the only place I've ever spoken where the words aren't written for me. They're written by me. And they matter more than anything I've ever said." He took a final breath. And if even one justice here believes that families like the Bellows deserve more than silence and a signature on a seizure form, if even one of you sees that this system has drifted from its promise, then maybe we have a shot at bringing it back. A silence swept across the courtroom like snowfall. Slow, total, reverent. Then Chief Justice Roberts, who had said nothing since his early challenge, spoke softly. "Thank you, Mr. Reeves." No sarcasm, no coldness, just simple, unmistakable respect. Keanu gave a quiet nod and stepped back. He didn't glance at the reporters or the row of startled attorneys. He just gathered his notes and returned to his seat, where no one dared speak. In the gallery, a few young law students exchanged looks of awe. "Who wasn't acting?" one whispered. "No," said another, barely above a breath. "He was arguing." Outside the courthouse, cameras flashed and analysts waited for commentary. But inside, as the next lawyer was called and the justices prepared to shift focus, the air still hung heavy with what had just taken place. Keanu Reeves had walked in carrying a battered briefcase and 10 borrowed minutes. He left, having changed the room, and maybe, just maybe, the law. By the time Keanu Reeves stepped out onto the steps of the Supreme Court, the air was no longer filled with skepticism. Instead, there was a hush of realization, the kind that settles after witnessing something transformative. The first few journalists remained still, blinking as though unsure how to process what they had just seen. Then someone clicked record. The first video clip to go viral wasn't polished or professionally edited. It came from a third-year law student seated near the back of the gallery, who had covertly captured Keanu's final words to the court. "The Constitution is not just for scholars or lawyers. It's for every family who's had their door kicked in, their life dismantled, without a day in court." The student posted it with the caption, "This wasn't acting. This was advocacy." She added the hashtag, Keanu the Counselor. Within the hour, over 250,000 people had shared the clip. By sunset, the number had doubled again. The energy on social media platforms shifted rapidly from confusion to fascination. Threads broke down his 3-part test. Legal TikTok influencers paired his moments with slow-motion transitions and dramatic soundtracks. Even casual fans were captivated. Keanu Reeves, the Hollywood actor, had just given one of the most eloquent constitutional arguments in modern Supreme Court history. But it wasn't just the public that took notice. CNN's legal analysts ran a special segment that night. One former federal prosecutor admitted, this was not a vanity performance. He was referencing originalist interpretations with greater fluency than some full-time scholars. On MSNBC, a panel of civil rights attorneys hailed Keanu's framing of due process and property rights as game-changing. Law school forums exploded with discussions. Professors who had previously dismissed the brief were now assigning it as required reading in constitutional law courses. Hashtags emerged and multiplied. Legal Reeves started trending on Twitter in less than 12 hours. Keanu the Counselor followed, propelled by side-by-side videos showing him cross-referencing Jefferson letters and calmly responding to Justice Roberts' most pointed challenges. A side-by-side clip comparing his courtroom performance to one of his iconic film scenes went viral. Except this time, he wasn't playing a role. This was real. UCLA School of Law confirmed his credentials publicly the next morning. A tweet from the official account read, "Yes, Keanu Reeves graduated top of his class. Constitutional concentration. Yes, we're proud." Attached was a candid photo of Keanu in a law library, scribbling notes late into the night. It garnered 4.8 million views in 10 hours. The courtroom had been the spark. The internet became the fire. The ripple effect extended far beyond social media. Within days, newspapers across the country ran stories under headlines like, "Keanu Reeves rewrites the legal script," and "Actor-turned-scholar leaves Supreme Court speech." The New York Times published a Sunday feature titled, From Box Office to Bench, Keanu's Constitutional Crusade, which delved into his years-long legal journey. The article revealed that during filming breaks, Keanu had quietly collaborated with a circle of UCLA law professors and former civil rights litigators. His focus had always been justice, not fanfare. At UCLA Law, faculty members who had once signed non-disclosure agreements now began speaking publicly. Professor Mara Ellison, a specialist in property rights and due process, appeared on PBS and explained, Keanu wasn't interested in shortcuts. He read everything. Federalist Papers, court transcripts. He once spent 6 hours reconstructing the arguments in Timms versus Indiana just to understand the judicial split. Clips from her interview were reposted by legal education accounts, spreading across universities and student communities. Civil rights organizations reacted swiftly and with force. The ACLU issued a formal statement praising Keanu Reeves for reviving an originalist framework that centers justice and limits overreach. The Brennan Center for Justice lauded the brief as one of the most robust constitutional arguments filed in the past 5 years. Both groups requested permission to republish portions of his brief in upcoming reports about civil forfeiture reform. Keanu, in typical fashion, declined personal credit, asking instead that the citations be attributed to the coalition of scholars who had guided him. Meanwhile, polling firms noticed something unexpected. A national survey, conducted just 3 days after the hearing, showed a 17-point spike in public interest around civil forfeiture. More tellingly, nearly half of respondents said they now supported restrictions on the government's ability to seize property without a criminal conviction. Among young adults, the number was even higher. On college campuses, student-led petitions began calling for legislative change, citing Reeves's framework as a model. In California and Michigan, grassroots coalitions started circulating drafts of a new Due Process in Property Act. At the same time, cultural commentators couldn't ignore the symbolic weight of the moment. In a world where actors were often dismissed as superficial, here was a man who had quietly prepared himself not for a role, but for a reckoning. Late-night hosts joked, "Turns out Keanu really is the one, and he knows due process." But beneath the laughter was awe. The shift was unmistakable. Keanu Reeves had gone to Washington not to perform, but to persuade, and now the public was listening. As the week unfolded, news outlets kept the story alive. CNN held a special segment titled When Hollywood Meets the High Court, where veteran legal analyst Margaret Ellison said, "What we saw was a seismic shift, not in celebrity involvement, but in how seriously the public is now engaging with constitutional law." She compared the moment to when Thurgood Marshall first stepped into courtrooms with radical but rigorous ideas, challenging entrenched power through clarity and courage. In response to rising curiosity, UCLA Law uploaded a digital archive of Keanu's coursework, including redacted versions of his amicus brief drafts annotated by professors. Within 24 hours, the university's website crashed from high traffic. Law schools across the country began reporting increased attendance in constitutional seminars. Several professors began designing new curriculum modules centered around the Reeves framework, exploring its originalist approach to takings, due process, and public use. Meanwhile, those directly affected by civil forfeiture began to feel seen. A viral video featured Tamara Brooks, a single mother from Philadelphia, who stood outside her former home holding a copy of Keanu's brief. "They took everything I worked for because someone else was arrested near my porch. No trial, no warning, but now someone stood up for people like me." Her words resonated in cities like Atlanta, Oakland, and Detroit. Town halls filled with residents demanding legislative reform modeled on the principles laid out by Reeves and his legal allies. Political leaders couldn't ignore the momentum. A bipartisan group of senators announced plans to reintroduce a stalled bill aimed at overhauling civil asset forfeiture practices. During a press conference, one representative said, "We've had hundreds of legal minds weigh in, but it took Keanu Reeves to bring the people's attention to what's really at stake." The bill was informally dubbed the Reeves Clause provision. Back in Los Angeles, Keanu declined most interviews but allowed one brief statement on NPR. "I didn't go to law school to be on camera. I did it because I saw injustice and because I believe the Constitution belongs to everyone, not just the powerful." His humility only deepened public respect. Even critics who had initially mocked his appearance at the court now offered quiet admiration. The story had moved beyond virality. It had become something deeper, a national conversation. In lecture halls, city councils, and kitchen tables, people weren't just talking about Keanu Reeves. They were talking about property rights, about fairness, about a justice system too long shaped by silence. And in that silence, one voice, steady, informed, and unexpected, had changed everything. Keanu Reeves didn't start studying law for accolades or to silence doubters. It began with grief. Years earlier, one of his closest friends, Aaron Delgado, lost everything after a civil forfeiture action stripped his family of their home. Aaron had sublet the lower unit of a modest duplex in Inglewood. Unbeknownst to him, the tenant was later arrested for a non-violent drug offense. Within weeks, the government seized the entire property, even though Aaron wasn't charged, never had his day in court. Just like that, the home was gone. Aaron spiraled, eventually sleeping in his truck and struggling with depression. He died of pneumonia the following winter. Keanu attended the funeral quietly, sitting alone in the back row, sunglasses on. That night, he opened his laptop and typed 3 words into a search bar: civil forfeiture law. He read for hours, then days, then weeks. The injustice gnawed at him. Eventually, he did more than read. He enrolled. At UCLA Law School, he studied under his birth name, Charles Reeves, blending into evening classes and research groups. One of his professors, Evelyn Marsh, immediately noticed something different. He wasn't there for prestige, she later said. He was there because the law had failed someone he loved. Evelyn took him under her wing, guiding him through advanced constitutional seminars and historical source materials. She pushed him to ground every theory in case law and founding-era documents. They debated Madison, wrestled with Blackstone, and dissected 19th-century forfeiture precedents that most law students never even read. Keanu also joined an informal study group composed mostly of ex-public defenders and community advocates. They called themselves the Redliners, a quiet nod to the neighborhoods where many of these seizures occurred. Their meetings weren't polished or performative. They talked about systemic patterns, procedural loopholes, and real-life families they couldn't save in time. Keanu never said much about his celebrity status, but he listened, he took notes, and when he finally spoke up, it was always with calm clarity. Every line in his eventual brief came from those nights, those stories. The legal theory wasn't abstract. It was built from the floorboards of homes that should never have been lost in the first place. The grief that drove him deeper into his work wasn't abstract. It wore the face of someone he had once called a brother. Marcus Ellis, a childhood friend and former Marine, had returned from deployment to find the city he left behind barely recognizable. The duplex he inherited from his grandmother was in a neighborhood flagged by a city redevelopment agency. When narcotics were found in an alley 3 blocks away, nowhere near his home, the property was seized under civil forfeiture. Marcus fought it, at first with disbelief, then with desperation. Keanu helped where he could, but the process was already rigged. The court filings were cold, the deadlines inflexible, the financial pressure unrelenting. Marcus lost the house, and 6 months later, he lost himself. Keanu attended the funeral quietly, sunglasses masking the ache. No cameras, no press, just a folded flag and a grave that should never have been dug. That moment became the seed. The night after the funeral, Keanu stayed up reading every statute on civil forfeiture in the California Code, then every Supreme Court precedent dating back to 1790. He didn't stop for days. What began as mourning evolved into mission. Marcus never got his home back, but Keanu would make sure others like him never lost theirs in the first place. When he wrote the Bellows brief, he included Marcus's story, not by name, but in principle. Every argument about due process, every example of disproportionate impact, every footnote pointing to systemic abuse, Marcus was in there, alongside the mothers and pastors and veterans who had trusted him with their pain. And when the brief reached the court's docket, it didn't come wrapped in prestige. It came wrapped in purpose. The media called it a celebrity stunt. The legal world ignored it. But Keanu knew what they didn't. The foundation had already been laid. Quietly, precisely, personally. What he carried into that courtroom wasn't just a legal theory. It was a lived testimony of injustice endured, of dignity denied, of truth finally ready to speak. He didn't come to the Supreme Court to perform. He came to redeem what the system had tried to erase. 6 weeks after the oral argument, the nation held its breath. In a courtroom where precedent rarely bent, the case of United States v. Bellows became a headline that reached far beyond legal circles. Law students dissected Keanu Reeves' amicus brief in online forums. Civil rights groups cited his oral argument in white papers. Editorials debated whether the Supreme Court would acknowledge a celebrity's contribution to constitutional doctrine or quietly sidestep it. The decision came on a Monday morning, just after 10 a.m. In a 7-2 ruling, the Supreme Court sided with the petitioners. The Bellows family, whose home had been seized by federal forfeiture agents without criminal charges, would have their property returned. But more than that, the ruling reset the boundaries of civil forfeiture law across the United States. The majority opinion bore a signature no one had predicted: Chief Justice John Roberts. Observers who had watched his earlier skepticism toward Reeves now found themselves reading a 43-page opinion that quoted Keanu's exact words directly and reverently. In the second section of the ruling, Roberts wrote, "This court adopts in substantial part the historical framework advanced by counsel for amicus Reeves. His proposed 3-part test for evaluating the constitutional limits of civil forfeiture aligns not only with the text and structure of the Fifth Amendment, but with the intent expressed in founding-era materials, including letters and early state cases we now recognize as foundational." In the next section, Roberts detailed that 3-part test. 1. A demonstrable and substantial nexus between the property and criminal activity. 2. Proof that the property owner either had knowledge of or consented to the activity. 3. That the forfeiture serves a specific public use, not merely general revenue. Justice Sonia Sotomayor concurred, writing, "What this case revealed was not simply doctrinal drift, but moral dissonance. Mr. Reeves's framing reminds us that constitutional protections exist to serve real people, not abstract policy." Justice Alito, often seen as a conservative voice favoring law enforcement interests, joined the majority, and in a remarkable shift, his concurrence included the phrase, "The historical insight offered in Reeves's brief is unmatched in modern amicus filings." Outside the court, the media reaction was immediate and explosive. Cable news channels flashed the headline across their tickers: "Supreme Court quotes Keanu Reeves in landmark, quote, civil forefront," end quote. Social media erupted, with legal scholars and celebrities alike weighing in. Hashtags like "reviews reruling" and "Justice Keanu" began trending within minutes. At UCLA Law, where Keanu had quietly graduated at the top of his class with a focus in constitutional law, students gathered in the atrium to read the opinion aloud. Professors who once questioned his academic pursuit now assigned his brief as required reading. One faculty member, Professor Evelyn Marsh, his mentor, choked back tears during a faculty roundtable. "He didn't want fame in this building," she said. "He wanted impact. He wanted clarity." Roberts' opinion did not just cite Reeves's ideas. It mirrored his tone. His language became more grounded, less legalistic, reflecting a desire to connect with the people most impacted by civil forfeiture. In one section, Roberts wrote, "The Constitution does not grant the government license to disassemble the lives of its citizens without conviction or due process. A child's home, a grandmother's porch, a community clinic. These are not fungible assets. They are anchors of dignity." Keanu's influence was unmistakable. In the final pages, Roberts went further. He acknowledged the court's past errors without naming them, but positioned the Bellows ruling as a correction. The law evolves when it listens to the quiet voices who speak with conviction, not credentials. Mr. Reeves reminded this court that our job is not merely to apply precedent, but to interrogate it. The courtroom had been silent when the ruling was read, but inside the legal world a storm was brewing. Organizations began immediately filing appeals using the new framework. Property owners who had been displaced without trial now had a path back to justice. Public defenders and nonprofit attorneys began adapting the Reeves test into their legal strategies. Even critics of celebrity activism had to admit the obvious. This wasn't performance. This was precision. Keanu Reeves had done what few could. He had not just won over a courtroom, he had reshaped the law. Keanu Reeves received the news quietly, from a wooden bench outside a modest garden in Echo Park. His phone buzzed with messages, some from law professors, others from families he'd met during his research, but he didn't respond right away. Instead, he closed his eyes, listening to the wind rustle through the leaves. It wasn't about victory. It was about validation. That the long nights poring over dusty legal documents, the patient hours spent walking the same streets as the people affected, and the painful memories of losing someone to a system they couldn't fight. It had all meant something. Later that evening, he spoke at a press conference arranged by a local justice nonprofit. The microphones were loud, the lights were bright, but his tone was steady. "I wasn't there as an actor," he said. "I was there as a citizen. Someone who believes the law should protect, not punish, the people who are already fighting to survive." He paused before continuing. "And I wasn't alone. Thousands of lawyers, advocates, and families have been fighting this for years. If my voice helped shine a light, then I'm grateful. But the real work belongs to those who never stop trying." Applause broke out, not the polite kind, but the raw, emotional kind that came from people who felt seen. Over the next few days, Keanu avoided the spotlight. He turned down interviews from the largest networks. When asked by a New York Times journalist if he would consider more legal cases, he said only, "If the Constitution calls, I'll answer." Behind the scenes, he quietly funded a new scholarship for law students pursuing constitutional reform, naming it not after himself, but after his late friend, whose home had been unjustly seized. At the Supreme Court, the majority opinion was already being printed in law reviews across the country. Students highlighted passages, professors rewrote syllabi, and in the final footnote of the official ruling, tucked neatly beneath the final citation, sat a sentence rarely seen in judicial writing. The court acknowledges with gratitude the amicus brief submitted by Mr. Keanu Reeves, whose historical research and legal clarity were instrumental in informing this opinion. A quiet legacy had taken root, one built not on celebrity but on scholarship and the courage to speak when no one expected you to. The morning after the Supreme Court's decision, Keanu Reeves walked past a crowd of reporters outside his modest home in Laurel Canyon. Microphones extended. Flashes popped. But he said nothing, not out of arrogance, but principle. When someone called out, "How does it feel to make history?" he simply gave a small nod and kept walking. Later, when pressed by a journalist via email for a quote, he responded with one line, "It wasn't about me. It was about the people." And that remained his stance. Instead of basking in the spotlight, Keanu quietly launched the Reeves Foundation for Due Process Reform. There were no televised announcements or celebrity endorsements, just a simple message posted online. Every person deserves protection under the law, especially the ones who've been silenced. The Foundation's first initiative was opening free legal clinics in communities hardest hit by civil seizure abuse. The first location, housed in a refurbished community center in south-central Los Angeles, opened within 30 days of the ruling. Keanu had personally visited the site 3 times during renovation, insisting the conference rooms have thick doors for privacy, not appearance. The staff included young lawyers, retired public defenders, and students from his alma mater, UCLA Law. He showed up on opening day unannounced. Dressed in a plain black jacket and jeans, he waited in the back until the ribbon was cut. Then, without drawing attention, he slipped inside to speak with families filling out intake forms. Some recognized him, most didn't. He sat beside a woman trying to save her mother's home from a wrongful seizure. He didn't say he was Keanu Reeves. He just asked, "What happened? Tell me everything." By noon, he had spoken to 6 families. Before leaving, he stepped into the break room and thanked every volunteer, from the attorneys to the high schoolers refilling coffee pots. As he turned to leave, someone asked what the next step was for the foundation. He paused, then said, "We listen, we rebuild, and we make sure no one goes through this alone again." 2 weeks later, Keanu quietly enrolled as a guest lecturer at UCLA Law School. The seminar was titled Originalism, Justice, and the Real Lives Behind the Law. The course filled in under 10 minutes. No fanfare, no press, just 30 students sitting in a semicircle, notebooks open, waiting. When he entered the room, the only hint of his identity was the battered leather briefcase he had carried into the Supreme Court. He didn't talk about himself. He talked about Madison, about the delicate architecture of the Fifth Amendment, about due process not just as a legal phrase, but as a moral contract between government and citizen. He shared redacted stories of real families impacted by wrongful property seizures. Students leaned forward, absorbing not just legal theory but the lived implications of abstract clauses. "What does it mean," he asked one afternoon, "to protect something you'll never personally benefit from?" A student responded, "It means you're doing it right." Outside the classroom, Keanu continued working behind the scenes. He partnered with public interest firms to identify communities eligible for property returns under the new ruling. He funded anonymous grants to help elderly homeowners pay back taxes the state had used as justification for seizures. He even hired coders to build a free digital tool allowing people to check the legality of forfeiture actions in their zip code. And still, he never spoke at a press conference, never posted online about his efforts. When a major news outlet requested an exclusive interview, offering to put his face on their cover with the headline, "The Star Who Saved Homes," he declined. He forwarded the opportunity to one of the mothers whose house had been protected by the court's decision. She did the interview instead. Behind closed doors, Keanu visited her that same weekend. Her name was Diane. She had lost her husband to cancer the year before. The state had nearly taken her house over a clerical error tied to his medical bills. They sat at her kitchen table, drinking sweet tea, the air thick with gratitude. She reached across the table, touched his hand, and whispered, "You gave me my life back." He just smiled and said, "No, you never lost it." The Reeves Foundation quietly expanded. What began with a single office in Portland grew to include pro bono hubs in Atlanta, Detroit, and Albuquerque. Each clinic was run by a team of young attorneys, most of them first-generation graduates, many of them former seizure victims themselves. Keanu never put his name on the door. He simply called each site the porcha, a nod to the place where families gather, where neighbors talk, where problems are faced without judgment. One morning, a letter arrived at the Los Angeles office. It was handwritten, smudged at the corners, addressed only to Mr. Reeves. Inside was a photo of a small one-story home with fresh siding and new steps. On the back, in careful cursive, it read, "You fought for this. My grandkids now sleep safe. Thank you for believing people like us deserved better." That evening, Keanu walked through the original garden beside his house. It had been overgrown during the months he spent preparing the case. He bent down, ran his hands through the soil, and began clearing it out, row by row. It wasn't symbolic. It was habit. A reminder that justice, like a garden, requires work. Quiet, constant, grounded work. That night he hosted a small dinner. No celebrities, just 5 people, 2 law students, a community organizer, an appellate lawyer, and his former professor, Evelyn Marsh. Between bites of roasted vegetables and cornbread, someone asked, "Do you think the court will remember your argument?" Keanu paused, then looked around the table. "I don't care if they remember me," he said. "I care that they remember the law belongs to everyone, even to people who've never read it." The table went silent. Later that night, before bed, he opened his old leather briefcase and pulled out the printed majority opinion. He reread the lines where the court had adopted the very test he proposed. The margins were still marked in pen from the night he finished writing it. At the bottom of the page, he scribbled something new. Justice isn't loud, it's steady, and sometimes it just needs someone willing to carry it one step further. He folded the paper gently and placed it back where it came from. Keanu Reeves arrived just after sunrise, unnoticed, just as he preferred. There were no cameras, no reporters, no staged photo ops. Only a small gathering of neighbors, local volunteers, and the Bellows family standing near the edge of the restored community center. In front of them, a young sapling waited to be planted, its roots wrapped in burlap, its slender trunk swaying gently in the breeze. The soil had been prepared by the same people who had once feared they'd lose this space forever. It had once been marked for seizure, the land caught in the wide dragnet of government forfeiture. But now, because of a case argued not by a traditional lawyer, but by an actor turned constitutional advocate, it was being transformed into something hopeful. Keanu joined the circle silently, dressed in a worn jacket and jeans. His eyes settled on the little girl with braids who stepped forward. Maya Bellows, age 12. Her family had lived across the street before the legal battle began. She had written a letter to the court that no one had read aloud, except Keanu. Her words had been woven into his closing argument. She looked up at him now, wide-eyed but brave. "Thank you for getting our home back," she said, wrapping her arms around his waist. Keanu crouched, meeting her eye level. "Thank you," he said softly, "for holding on when it got hard." They planted the tree together. Her small hands helped guide the roots. His steady ones pressed the soil back around the base. Someone handed them a tin watering can, and Maya poured while Keanu held the stem straight. A simple plaque had already been set in the ground nearby. It read, "Justice grows when courage speaks." The words weren't his. They were from Maya's letter. The tree, a modest red maple, was chosen not for grandeur, but for endurance. It would grow slowly, season by season, its leaves turning crimson each fall, a quiet landmark to mark a moment when history shifted, not with fanfare, but with principle. As they stood back to admire their work, no one clapped, no one needed to. In the stillness, a deeper acknowledgement settled over everyone. This wasn't a monument. It was a beginning. After the planting, the small group drifted toward the front steps of the community center. Families passed around paper cups of coffee. Some brought muffins, others just their presence. There was no formal ceremony, just murmured conversations about school, groceries, and how strange it felt to smile again without hesitation. For months, this neighborhood had lived under the shadow of a government notice tacked to the front door. Now the paper was gone, and in its place stood something rooted. Keanu didn't make speeches. He never had. Instead, he wandered the garden beds where children had once drawn chalk outlines of their homes, afraid of losing them. He noticed that someone had placed wind chimes in a fig tree, their delicate sound fluttering in the air like laughter. He smiled quietly. Then someone tapped his arm. It was an elderly man named Mr. Darrell, a retired bus driver who had attended every city zoning meeting during the court case. He shook Keanu's hand with both of his. "I just want to say," he said, voice rough with emotion, "you didn't have to show up like that in court. But you did. And it made us feel seen." Keanu nodded humbly. "You were worth seeing." A few others joined them, sharing pieces of their stories. A mother whose son had been accepted into college after nearly dropping out during the eviction scare. A nurse who had been organizing food drives from the parking lot, unsure if she'd have a place to park next month. A teenager who had built the raised garden beds with salvaged wood from a nearby demolition site. All of them had found a way to hold on. Keanu hadn't saved them. He had amplified their strength. Someone passed him a pen and asked if he'd sign the inside cover of the court decision pamphlet that had been reprinted by a nonprofit. He did, writing only, "To justice. Always." Then a quiet voice interrupted from the edge of the circle. "Do you think we can keep it?" Keanu turned. It was a boy holding a small white card. The deed to the center, officially returned. Keanu walked over and placed a hand on his shoulder. "You already did." The boy smiled, clutching the paper like it was gold. As the sun settled lower in the sky, the gathering began to thin. Parents called children home for dinner, and neighbors exchanged quiet goodbyes. But Keanu lingered by the tree. He watched as Maya Bellows, the 12-year-old girl whose name the case had carried, returned with a watering can nearly half her size. Her sneakers were caked in garden soil, and her sweater sleeves were pushed up to her elbow. "Mind if I help?" Keanu asked gently. She looked up, surprised, then nodded with a grin that was all front teeth and bright courage. Together they poured water over the sapling's base, darkening the earth. Maya crouched beside the trunk and gently brushed the soil with her hand, patting it into place with careful reverence. "My mom says this place feels like breathing again," she whispered. Keanu looked down at her. "Your mom's right. Justice isn't just a law. It's air. We forget we need it until it's taken away." Maya nodded solemnly, then pulled something from her pocket. It was a small piece of wood, shaped like a heart. Carved into it were the initials MB and the date the decision had been announced. "Can I leave this here?" she asked. "So we remember." Keanu helped her place it near the roots. Then she stood and looked up at him. "Thank you for getting our home back." He crouched beside her, his voice low. "Thank you for holding on. You gave everyone else permission to hope." As Maya joined her family, Keanu turned back to the tree. The plaque at its base gleamed in the fading light. "Justice grows when courage speaks." He reached into his coat and removed a folded piece of paper. It wasn't legal writing, just a note scribbled weeks ago after the court decision. On it, one sentence: "Sometimes the system listens, when the people remind it how." He placed it under a stone near the plaque, not for recognition, but for reminder. Then, without fanfare, Keanu stepped off the grass and into the street. No flashing cameras, no interviews, just a man with a quiet purpose walking into the deepening evening, the roots of justice growing quietly behind him. The morning light spilled through the quiet halls of the Reeves Foundation, casting long shadows over the legal library where Keanu often worked alone. The mail had been dropped off as usual. Thick manila envelopes, donation forms, handwritten letters from families touched by the recent ruling. But tucked between the usual stack was something unexpected. A small envelope, cream-colored, no return address. Just his name, handwritten in neat, deliberate strokes. Keanu Reeves. He turned it over, paused, broke the seal. The handwriting inside was unmistakable. Mr. Reeves, this court has seen countless arguments over the years, some brilliant, others necessary, few that are both. Yours reminded me what this court is for. Thank you. John G. Roberts, Chief Justice of the United States. Keanu sat still for a long moment, the weight of those few lines pressing deep into him. It wasn't pride he felt. It was something older, something rooted in humility and quiet recognition. He didn't call the press, didn't share it with colleagues or online followers. But he did drive across town, envelope in hand, to a quiet apartment nestled in a red brick complex shaded by oaks. There, he knocked on the door of Professor Evelyn Marsh. When she opened it, her eyes widened. "Is everything all right?" she asked. He nodded, then simply extended the letter. She took it with gentle fingers, read slowly, then brought her hand to her mouth. A soft sob escaped before she could stop it. "I never thought," her voice cracked, "I never thought the law would hear our voices." Keanu stepped beside her, touched her shoulder. "It did," he said softly, "because you taught me to speak." She sat, letter clutched to her chest, tears falling freely now, not from sorrow, but from something long buried. Belief. For years, she had argued that justice was not a theory, but a lifeline. She had been told to quiet down, to conform. And now, the highest judge in the land had written to her. Keanu glanced at the window where sunlight cut across her shelves stacked with legal journals and half-marked manuscripts. "Sometimes," he said, "it just takes one quiet voice in a loud room." She nodded, eyes still wet. "And sometimes, that voice echoes." Later that afternoon, Professor Marsh carefully placed the letter into a protective sleeve, sliding it between pages of her old annotated copy of the Federalist Papers. It wasn't about preserving it as a relic. It was about honoring the moment. The simple note now sat among centuries of American legal theory, not as decoration, but as an affirmation. Keanu stayed for tea, as he always did when he visited. She poured gently from a clay pot, her hands steady despite the emotional weight of the morning. They sat on the balcony overlooking the quiet courtyard, the sound of children playing in the distance, an echo of the future they were still trying to shape. "You know," she said after a long silence, "when you first came into my classroom, I thought you were lost." He smiled, sipping slowly. "I was. But you weren't looking for celebrity, you were looking for meaning, and that's rare in any courtroom." Keanu didn't reply. He simply let the weight of her words settle between them like a truth too sacred to speak aloud. Professor Marsh looked out across the courtyard. "When I was your age, I tried to argue a case about land seizures. They laughed me out of chambers, said I was emotional, said the law didn't need heart, only structure." "Maybe," Keanu said, "they just hadn't seen what happens when the heart and structure align." She nodded. "Maybe." There was a photograph on her side table, faded but framed carefully. A young Marsh standing beside her father, who'd lost their family home to a government seizure decades ago. That loss had fueled her lifelong work. It had also made her invisible to the legal elite. But now the court had listened. Not because she demanded it, but because someone she had mentored carried her work into the room. Not as an echo of pain, but as a declaration of justice. She reached across the table and touched Keanu's hand. "You didn't just argue for the Bellows family," she said. "You argued for every scholar who ever felt dismissed, every family who thought they were too small to matter." He looked back at her. They weren't too small," he said. "They just needed someone to carry their voices where power sits." That evening, Keanu walked alone through the quiet streets near the Capitol. No cameras followed him. No entourage flanked his sides. Just the soft sound of his footsteps echoing off marble and brick, justly. The same families whose stories he had carried huddled around Ains opened the door. Her home had once been scheduled for demolition after a seizure she couldn't fight in court. Now, it stood untouched, protected by a ruling that bore Keanu's fingerprints. "He promised," Keanu replied. Inside, several families had gathered for dinner. Casseroles lined the counter, children played under the dining table, and laughter floated through the air. He hugged him and said, "We're home again." After the meal, Keanu a folded piece of paper. It was a drawing, the Supreme Court in crayon, with small figures holding hands at the steps. At the bottom, "I heard you." And so did the court, because of its words. Because of what it meant, history and heart had aligned, just long enough to let justice bloom. Keanu sat quietly at his desk, the fireplace behind him casting slow, flickering shadows across the room. Outside, the snow had started again, blanketing the rocky lands. Pen paused, then wrote in deliberate strokes across the top line. He stared at the words, letting their weight settle in. They weren't dramatic, they were simply true. The morning after but to text messages from families whose lives had changed. Photos of reopened clinics, children back in homes once boarded shut. Letters thanking him not for winning, but for caring, for listening, for showing up. In his journal, he scribbled, "Justice should not require fame to be heard." A knock at the door that morning had come from a local teenager, Lewis, who had seen the court videos. "I thought law was for rich people," he said again. "The law speaks loudest when it listens first." Memories returned. Late nights at UCLA, poring over dusty with Professor Marsh, long drives to meet and public housing volunteers, all teaching each other how broken systems steal not just property, but dignity. It had never been. It was a promise, one he'd made silently, to every friend, and now out the window. The garden outside was covered in snow, but he knew the roots were there. Wait, growing. Later that afternoon, Keanu walked the narrow trail behind his estate. The wind carried no cameras, no applause, just the quiet of pine and sky. His phone buzzed in his coat pocket, another media request, another headline wanting a quote. Moment. At the edge, its young branches now bore the weight of winter, thin and bare, yet still upright. A small wooden tag swayed gently beneath one branch. It read, "Justice grows where courage roots." That phrase hadn't been written by him. It had come from Maya Bellows herself, the 12-year-old girl whose family had lost everything, then won everything back. Her words had been carved there by her own hands, with a wood-burning pen her mother gave her. When she handed it to Keanu during the quiet ceremony, she whispered, "Now it'll grow with you too." He reached down, gently brushing snow from the base of the tree. In the stillness, he felt the echo of every voice he'd met through the case. Each person who had been crushed by silence, and who now dared to speak. Not just him, all of them. He pulled out his journal again, flipping past pages of legal notes, case analysis, and scribbled thoughts from late nights in D.C. He turned to a fresh page and wrote, "This wasn't just about restoring law. It was about restoring trust." Down the hill, voices carried faintly from a community meeting he had helped organize. Law students, housing advocates, everyday citizens. They weren't there because of him. They were there because they believed something could change. And for the first time in a long time, so did he. He closed the journal and stood again. The tree behind him stood taller somehow, or maybe he had simply stopped rushing past it. That evening, as the sun dipped behind the mountains, Keanu sat at his desk, a single lamp casting soft gold across the room. He reread the final journal line he'd written earlier. This wasn't just about restoring law. It was about restoring trust. A soft knock came at the door. Professor Marsh. She had stayed for dinner, insisting on washing dishes while he finished his thoughts. "Time to rest," she said gently. "Movements need their leaders to sleep." Keanu smiled. "I'm not leading anything, just trying to keep a promise." She looked around the room, at the maps, the articles, the quiet dignity of his work. "You kept it, and you lit a path for others." He didn't answer right away. Instead, he looked to the window, where the stars had just begun to appear. Silent, steady, unshaken. Then, in the final entry of his journal, he wrote, "I came to speak for one case, but I left with a movement. Brilliance isn't loud. Sometimes it walks in late and rewrites the ending. Have you ever been underestimated and proved them wrong? Share your story below. What mission should Keanu take on next? Subscribe to Follow the Fight for Justice.